Evening, everyone. Thank you for joining us. My name's Cormac. I'm a junior barrister here. I'll be chairing this evening. We had initially proposed this seminar about the minimum service levels bill in the transport industry. Since then, the government has introduced further legislation which will extend it to health services, fire and rescue services, education, and border security. So hopefully some of our speakers will chat about that. We've got 4 speakers this evening. We have Eddie Dempsey, who's here on my left. He is the Senior Assistant General Secretary of the RMT and has been a prominent figure in their long-running dispute over pay conditions and job security in the rail industry. On my right, we've got Nick Toms, and he's a barrister here at Doughty Street, specialising in employment, and particularly in collective labour law issues like blacklisting. My far left is Pippa Woodrow. She's another barrister here at Doughty Street, specialising in public and crime and in particular protest work. She was recently involved in the Reclaim the Streets litigation about the vigil following Sarah Everard's murder. And on screen somewhere we have Justin Matters MP, who I understand is stuck in Parliament. Justin Matters is the Labour MP for Ellesmere Port and Neston, and he's also the current Shadow Minister for Business and Industrial Strategy and for the Future of Work. The format of tonight's session is that each speaker will talk for about 10 minutes, bring their perspective to the proposed legislation. So it's the Minimum Service Levels Bill and the Public Order Bill. And then hopefully we'll open up to questions and you'll have lots of questions for our brilliant speakers. I think Pippa's going to kick us off.
Sure. There we go. There we go. Right. Now, this introductory slide, do I have to press? There we go. So now someone has kindly changed my name. This is the slide I want to get to. So I'm going to talk about the Public Order Bill. As Cormac said, I am mainly involved in public law and crime, criminal justice related public law. And I want to be clear about my view up front, and you'll see the tagline. Now, it's up to you to decide whether the question mark attaches to the word dystopian or future, bearing in mind the legislation that has already been passed. But being upfront from the beginning, my view is that the Public Order Bill is an abomination. It is deeply repressive and illiberal. And it puts us in the company of Russia, Belarus, the Philippines, a whole host of nations who we on the international stage condemn for their approach to human rights and in particular to protest. But the provisions in this bill in many ways go further than the ones in those countries. So repressive, illiberal, and one might say hypocritical. But let's dive into what they are. I don't know if you can see that particularly, but what I propose to do in my 10 minutes, I hope it'll be 10 minutes, apologies if it's a bit more, is try and give you a whistle-stop tour. Obviously, I'll have to cut some corners, but a whistle-stop tour of what's in the bill, and then talk about why it might not be a good idea. So starting with the first part, so it creates a slew of new offences, not a huge amount actually, I think it's 7 or 8, but new offences. The first is in relation to locking on. So what they do is they criminalise a range of actions where those actions cause or are merely capable of causing serious disruption to 2 or more people or an organisation. And you have to intend or be reckless as to whether there will be such disruption. So I'm unpacking that for a minute. You don't actually have to intend anything. There doesn't actually have to be any disruption, and you only have to potentially disrupt 2 people. And the actions that are criminal in those circumstances now under this bill, if it passes, are firstly locking on, which is defined as attaching oneself to another person or to an object or land, or attaching another person to another person, or attaching another object to a land. The second thing is tunnelling, so creating or participating in the creation of a tunnel or just being present in a tunnel. Then you've got criminalisation of obstruction or interference with a series of different networks or organisations. So major transport works is one. And then there is key national infrastructure, and a list is given of key national infrastructure. And it may surprise you to know that one of our key national infrastructures, alongside sort of things that you might think are fairly essential, like electricity, gas, etc., that we use for safety purposes, alongside that is newspaper printing infrastructure. Can't imagine why that might have been included, but that is apparently key national infrastructure, which will be criminalised under the circumstances we talked about before. And then not only are those things potentially criminal, but there's also an offence of going equipped for any of those things. And that means that it will be an offence to have with you on your person outside of your home anything that you intend may be used in connection with such an offence, and not even necessarily by you, by any other person. Now, when you stand back from this, that could be pretty much anything. Things that might be used in connection with serious disruption could be a flyer, because people are handing out flyers and blocking a road. It could be you're wearing a belt and you use it to connect with your neighbour. It could be a water bottle that you provide to somebody else who is causing serious disruption. I mean, it's genuinely a kind of mind-boggling list of items that could mean that you've gone equipped, subject to your intention. So this really is sort of a really wide-ranging criminalisation of activity related to protest. The next thing that the bill does is to expand stop and search powers. It expands the kind of, if I call it the ordinary stop and search power, where there are reasonable grounds to believe that there's an offence being committed. It expands that to these new offences and also to the offence of recklessly causing a public nuisance, which we got in the last protest related legislation, the Police Crime Sentencing and Courts Bill, and also to willful obstruction of a highway. And so thinking again how that relates to the breadth of those provisions previously, somebody can stop and search you if they have a reasonable suspicion that you might be wearing a belt, or you have a bottle of water that you might provide to somebody over there who's causing a disruption, or that you have a bike lock or something of that kind. But perhaps even more concerningly, the bill goes on to provide for a sweeping new power for police to stop and search without having to show reasonable suspicion of any offence at all. They can stop and search at will any person without having to give any reason. And the circumstances in which that would be possible is where a senior officer, an inspector or above, reasonably believes that any of the aforesaid offences may be committed in the area, or people are carrying prohibited objects, and that is objects that are made or adapted for use in connection with those offences. So this is really broad language. Suspicionless stop and search of this kind has only previously ever been introduced for really serious violence, so knife crime in particular, or terrorism. And so that is where the government see protest, in company with terrorism and serious violence. The periods within which police can stop and search for any person within a particular area can be for as long as 24 hours. And it is a criminal offence for which you can be imprisoned to obstruct such a stop and search of any person. All of these offences carry sentences of imprisonment. The third thing that the Act does is to create civil orders that are modelled on football banning orders, but they are protest banning orders. And they effectively bar particular individuals from participating in any protest on the basis that they have been involved in activities on 2 occasions over a 5-year period, that's all that's required, which caused or didn't cause but were likely to cause serious disruption to two people, or you didn't do anything at all but you contributed to somebody else doing one of those things. So you don't actually have to have ever been to a protest to be banned from going to protests under these civil orders. In addition to being banned from participation in protests, these orders can have conditions attached that will ban people from going to particular places, from seeing certain people, carrying particular items, engaging with others on the internet about organising protests, for example. They can be tagged, they can have a curfew at their home for periods of time, they can be required to go to the police station, and these orders can last in the first instance up to 2 years, but can be extended indefinitely. Breach can see you sent to prison. And all of this can be done on the basis of the civil standard of proof. So a judge doesn't have to be sure of you having engaged in the activities that would lead to the imposition of this, just on the balance of probabilities. And again, it can be on the basis of this weaker evidence under the civil procedure rules, which would allow for police intelligence and that sort of thing that's unverified. So it's a weak protection, one might think. And this can be imposed on conviction or even where somebody hasn't been convicted of any offence. And so given the extremely broad and vaguely defined terms of all of this, this potentially risks depriving a very large number of people of their fundamental human right to protest. The final thing, big thing, there are a couple of technicalities, but the final big thing that the bill does is to provide for the power of the Secretary of State to seek preemptive civil injunctions in the courts. We've seen a huge proliferation of civil injunctions from I say private companies including HS2, for example, who go to the court because they're worried about protesters, and they get what's called a persons unknown injunction, which prohibits anybody, persons unknown, from doing certain things, entering sites, for example. And once that injunction is in place, breach of its terms amounts to a contempt of court. So it's a different way to criminalise that conduct. And usually it's a party that's affected that can seek these injunctions, but the Secretary of State will now be able to do that under certain circumstances. Once somebody is found in contempt of court, if they are, they can be sent to prison for longer even than the offences provide under the specific offences provide under the bill. I think it's up to 2 years. And in addition, because of a quirk in the procedure rules, you're also on the hook for the whole whack of civil costs. So there is a massive additional penalty where you have to pay, often could be hundreds of thousands of pounds in cost to the Secretary of State for the privilege of having been taken to court in this way. So it is hugely problematic. And of course, these are judge-led proceedings, so you don't have the protections of jury trials that you would if you were going through a criminal process where you might get 2 years in prison. So that's what it does. Is it lawful, is a question I was asked, which is why I put this slide in. Well, technically, I suppose, yes, in the sense that the King in Parliament is sovereign. Parliament can do what it likes. But there is, I think, a real problem with compatibility with the European Convention on Human Rights. The courts can't, in this country, strike down legislation because it doesn't meet human rights requirements, but they can make a declaration under Section 4 of the Human Rights Act. So perhaps the better question is, how do I go back? There we go. Is it ECHR compliant? I'm sorry, that's not particularly visible, is it? Sorry. Right, so the better question is it ECHR compliant? And the answer, I think, is not really. In fact, definitely not in many respects, and in respect of many of the provisions. And there are quite a lot of reasons in relation to the different provisions why that might be the case, but I've given just some headlines here that I'm going to run through quicker than I ought to, but I know that I'm probably running short of time. So the obvious point, of course, is that protest is a fundamental human right. It's not the case that this is just the government interfering with us when we wish they wouldn't. They are actively interfering with something that we have a positive right to do. And we have a positive right to do it because it is a social good. It is a pressure valve. If people don't feel that they have a voice as part of the system, then they may resort to other means that we don't want them to. Protest is good. It allows people to voice their concerns in a way that is part and parcel of the way that we want to engage in a democratic society. And it is also an engine for change and for social good. So it's not something to be tolerated. It is something to be protected and cherished. And people should be positively facilitated to do it. So say the courts. And fundamentally, this legislation will stop people, a great many number of people doing that. So in the first instance, of course, it's an interference with fundamental rights. Just addressing this list, I'm going to look at proportionality first. Many of these measures are just simply not necessary. We have the existing tools and offences to allow the police to deal with the behaviour that is hitting the headlines that the politicians are targeting by this legislation. It's already an offence, for example, to block an ambulance, etc. All of the things that we hear being given as examples for why more and more coercive legislation is needed, that is already catered for within legislation. And in many instances, the provisions go far farther than is necessary to deal with conduct that the government thinks is undesirable. In particular, the civil protest banning orders are, I would argue, they go far further than is necessary to achieve what the government wants to achieve, because they don't just prevent serious disruption, they prevent participation in protest. Legality, it's a fundamental principle, legal principle, that legislation of this kind that interferes with fundamental rights must be capable of certainty, it must be accessible, it must be foreseeable. So people must be able to know in advance, is their conduct going to be criminal or not, and how it's going to be treated by the authorities. And this legislation just doesn't meet that test. It is in very many respects vague, it is overbroad. One example, locking on is attaching yourself to another person. Well, if I link my arm with Eddie, have I committed an offence? I just don't know. I mean, I might have committed all sorts of offences. But that's just one example. Serious disruption, for example, isn't defined. There are quite a few examples, but I'm running out of time. The application, how this is going to be interpreted by the police, is unclear. There's a reasonable excuse defence in respect of the offences, but the law is, the next slide, is a series of cases for anyone who's a law geek and wants to look into it. I'm not going to go through it, but the law is in a bit of a mess about how reasonable excuse defences are to be interpreted. Some offences that imports a proportionality test, some offences it doesn't. We don't really know which are which until the court tells us, but how does that help police on the ground? You have to make these assessments at the time. It really is wholly unclear, and it's important that the police know what's going on, because by the time we get to court, you've already been stopped from protesting, the interference has already happened. So it needs to be really clear from the outset, and this legislation just doesn't it isn't good enough in that respect. Stop and search in particular, the suspicion the stop and search is likely, in my view, to be not compatible with human rights legislation. The European Court has considered these kinds of powers 4 times. One, they said it was okay in a wholly different scenario, but the other 3 times they said you can't do it. And the reasons that they gave in those cases were that legislation was overbroad, too many people could be caught up by it. It's overbroad in scope, the articles that you're looking for were too many. It was capable of catching too much and too much conduct. Risk of arbitrariness and discriminatory use, insufficient safeguards. There is no guidance attached to this to say that PACE codes, for example, will apply. There is, we know already, discriminatory effects in stop and search. That is multiplied in respect of protest. We know that stop and search I think it goes up 20% when there's protests happening on a weekend compared to when it's not, despite the fact that protesters are no more likely to be arrested after being stopped and searched than an ordinary member of the public. An absence of a regulatory code to tell officers when they can and can't make decisions to exercise this discretion to search people. And finally, the absence of a reasonableness safeguard within officers' decision-making means that it's really difficult for the courts to exercise any supervisory jurisdiction, because there's nothing for them really to scrutinise. That a JR simply doesn't work as an effective remedy. And so all of those reasons apply, I would suggest, to this legislation as a reason why it just doesn't comply with the legality principle. There are positive duties to promote and safeguard the right to protest, which this bill plainly flies in the face of. And there are also positive duties under the Right to Life, Article 2, and under Article 8 in relation to our environment. And as this becomes an increasingly important and urgent issue in terms of our public health in the context of climate change, I can see this sort of legislation coming up against those sorts of duties, as well as just the standalone rights to protest. So I'm going to skip past that one and finally just look at these two pictures to make two final points. Will it work? Well, it depends what you mean by work, I suppose. But I think there are two overarching points to make. The first is a picture on the left of one of my clients, Elliot Katurian, who has many cases now to his name. He has been through the courts many times, being prosecuted in respect of criminally and under civil injunctions. He is an example of one of a very small group of very committed protesters, and these are the people really that the government is concerned about. And this legislation will not stop those people. These are people that are prepared to go to prison. They are prepared to be arrested. This isn't going to stop that. What it will stop is a whole swathe of the majority of people who don't want to find themselves before the courts. It's going to chill those people. It's not actually going to deal with what they say they want to deal with. And secondly, a kind of broader point, and this is the picture of the Sarah Everard vigil on the right. Policing, as we are told repeatedly, is based on consent. And what this legislation does, following on from the PCSC Bill Act, is that it effectively passes the buck to the police. And they've got such broad powers to interfere with, clamp down on, stop people protesting, that they, in fact, become the arbiters of who can and can't protest. And that's not a position that they want to be in. The HMIC FRS have come out against the bill. They have said they don't want these powers and that they don't comply with human rights legislation. But what happens, and we saw it during the pandemic with very overbroad powers, including in relation to protest, is the police, because they want to be able to appear neutral, to remain sort of trusted, they feel that they have to appear even-handed and treat everybody the same. And so in order to be able to clamp down on you, they clamp down on everybody. And that's how we ended up in a situation on Clapham Common. And so we end up in a race to the bottom where all of our rights are affected. And so for all of those reasons, I would argue that this is a bill worthy of the bin and nothing else.
Thank you, Pippa. Eddie, over to you.
Yeah, thanks. Thanks for the invitation. It's a pleasure to come around and speak to you. It's, you hear me okay? I have to say it's a bit unusual to be speaking to an audience like this, not under caution or in confidence, but there you go. Look, I'm not going to go into the detail of the legislation. I'm sure Nick's going to do some of that. I'll try and give you a bit of an appreciation of how people like me feel about this legislation, our workers who are out in strike action feel about this legislation, and why we think it's happening. So, from the point of view of people like me, and by people like me, I mean trade unionists who are involved in taking action, from families who've got a history in that, some of them new to that. This appears to me to be an expression of how the state and big business are entwined, symbiotic, and one represents the interests of the other, and why we don't regard the state as being some kind of neutral body mediating in society, but one that is directly involved in representing the interests of people who frankly exploit the interests of my people. That is how we see it. And I'll give you some examples of that. I've been a railway worker for 15 years before I came onto the rail to work in a trade union. I was directly involved in strike action. I was involved in strike action at the time the government brought in the last raft of anti-trade union legislation. My father was a seafarer, he was a deep sea sailor. He was involved in a 1966 strike. And when the government couldn't win through supporting industry in that dispute, they simply destroyed the industry to get rid of the union. Because in their view, they were not going to have an island nation where 80% of trade comes in by sea, organised by people like me or my father or people we knew. My grandfather, he was a railway worker when he came over here from Ireland. Before that, his people were from a coal mining part of Ireland where they went out on strike for 11 months. And again, the state intervened in that dispute. And some of his brothers were involved in the lockout in Dublin in 1913, and we all know the history of that. And that's the sort of lens we see this legislation in. We see politicians bought and paid for by a corporate lobby representing the interests of big business against ordinary people. And that goes for the legislation that Pippa described to you, and that goes for the legislation they're seeking to bring in to prevent people like me rebalancing inequality in the workplace and in society. And the reasons we think this is taking place is because governments over many years, for my whole life in fact, through political decisions have sought to unbalance power in our society and empower corporations and empower those people who extract profits from the work of others and from owning our public institutions, some of them from owning the infrastructure in our country, wealth-making processes, and they seek to protect that. And how they do that is by bringing in laws, helping these employers, and trying to restrict the ability of people like me to organise and people who are just ordinary people out going to work from taking strike action. And so we've seen in recent times, in this latest wave of industrial unrest, that's a result of inflation being high, that's a result of a so-called cost of living crisis, but in reality it's the result of successive governments removing the ability of ordinary workers to bargain for better wages. And if you go back 30 years, I don't want to get too technical here because I'm not an economist, but if you look at unit prices, you'll see about 60% of the cost of commodities that were produced and sold in the marketplace, about 60% of the unit costs went to labour costs. And somewhere between 10 and 18% went in the form of profits. And if you skip 30 years to the modern time, you'll see that's completely reversed. You'll see profits are somewhere around 60% of unit prices in any given commodity. And you'll see labour costs are somewhere between 11 and 14%. And that is the same in Western economies, in Europe, in Britain, in the United States, and everywhere else. And what we're seeing at the moment is a growing, and I think a working class movement has started to find its feet, greatly diminished from years gone by, but nevertheless deciding that they want to take a fight on and make the case for ordinary people in this country. And the government wants to take the feet out from under it by bringing in legislation to rebalance once again the economy and power in society in favour of the people that pay their lobby fees, frankly. We see that in disputes where they brought legislation in to allow employers to bring agency workers in, to break strikes. We see that where they use taxpayers' money to indemnify and protect the profits of employers during times when we take strike action. And we've seen that for many years taking place. And now when that's not working and the debate in the court of public opinion, if you like, seems to be going against them, they're seeking to bring legislation in that is cruel, immoral, undemocratic and wrong on many different levels. And I'll give you a reason why it's so cruel. So if you take someone like me, the way I was brought up is there's, things you can do wrong and things you can do right in life. But one thing you don't do is cross a picket line. That is an ultimate red line. You must never do that. There is nothing lower. Worse than a taxman, worse than a bailiff. You don't break a picket line. Never. And no member of my family's ever broken a picket line. And that's how I was brought up. To me, that's anathema. But they want to bring in legislation that could put me on a work list, so-called, during an industrial action dispute. And I'll be told that I've got to break a strike, which I've been told all my life and brought up to believe is the worst moral crime you could commit, aside from some other things, but we'll just, we'll say it plainly, it's a disgraceful and immoral thing to do, is to break a strike. And so if I don't break the strike and I don't go into work when my friends and comrades are taking strike action, then they'll say to my friends and comrades who are on a picket line taking action, you will lose your legal protections and you could be sacked. So that's the quandary they want to put people like me in. Either you break a strike or go on a dole, which I'd be happy to do. I'd rather go on a dole than break a strike. But even if you don't break the strike, we're going to threaten your friends, the people you work with, the people you're in solidarity with, we're going to threaten them with a strike. And further to that, we'll make the dispute you're engaged in illegal. Now, there's 101 ways they can make a dispute illegal as it stands. The hoops we've got to jump through right now are bigger belief. I mean, the thresholds that we've got to meet, if politicians had to meet those thresholds, there'd be a very empty parliament, I've got to tell you that. But meet them we do, through hard work and organisation, we meet them at a cost. And then once we've done that, we've got to give an employer 14 days notice before we take any form of action. And any action that we do take could be argued is disproportionate to the dispute that we're involved in. And we've got to say to people, before we even get into dispute, in advance of getting into an industrial fight with any employer, we've got to specify on the voting papers what forms of action short of strike we might ask you to take. Now, I've got to tell you, these things develop in an industrial fight. It's sometimes not apparent to people what the best course of action is until you're in the ring and you've had a few slaps thrown. Sometimes it becomes apparent what the course of action might be, but you can't take it because you have to predict that in future and state that in an industrial action ballot before you even get in the industrial ring for a fight. You've got 6 months to win or lose a dispute because they know people who've been engaged in action for 6 months will find it tough when they've been taking action to vote again if they haven't seen results. So we've got to go back to our people and ask them to vote again to keep our mandate going. And you could be stopped for any kind of infringement. I remember being in a dispute that was nearly stopped because somebody within the organisation, a member of the union, had given advice to members of the union in their particular workplace that was regarded as an instruction. It had nothing to do with the national union or instructions given by us or anyone involved in making decisions in a dispute. But our whole dispute was nearly declared illegal for that, because that was regarded as a union giving an instruction that was outside of our legal brief. And I've subsequently seen disputes declared illegal for that, just stopped in its tracks. You can no longer take any more strike action in relation to that dispute. So we know the law is stacked on the side of the employers. We know the government is on the side of the employers. They're prepared to support them through legislation, through protecting their profits by giving them my money whilst we're on strike to make sure they don't lose a penny. And we've seen from disputes in the past just how far the state will be prepared to go in pursuit of that. They will use their friends in the media to demonise us as individuals and try to sap support of our own membership in their leadership. We know that they'll spy on us. We know that they'll lock us up. We know that they'll fit us up with charges that are untrue. I know people who were arrested during a whopping dispute who never put a foot wrong. I know people who were beaten up by members of the British Army dressed as police officers during Orgreave. I know people who were spied on. I know people who were threatened. I know people who've had child pornography put through their door during an industrial dispute, the message being, this is how we're going to fit you up if you don't bend the knee and do what we tell you. So we're not surprised that this is the latest salvo in an ongoing assault on working people in this country by this government and other governments, frankly. But what we've got to see from people in society more broadly is an appetite actually to stand up for our civil liberties, because despite what they tell you of us being unpatriotic, red, no good nicks and all the rest of it, some of us actually like this place where we're from and are quite proud of the history of the working class in this country. This is where the trade union movement is established, and we regard ourselves as being in the same cut as the suffragettes, as the Putney debates, as the Chartists. That's our history. We are the people we regard, although some might disagree with us, as being the people that brought democracy to this country, that brought the freedoms that all of us enjoy to this country, and regard ourselves as being part of a broader trend in society at large that yearns for freedom and civil liberties and the right to point out wrongdoing in society and stand up for what you believe in. And that's why it's so closely linked to what Pippa's been describing to you in other legislation the government's bringing in. And that's why we think that people broadly in this country have got to shake themselves out of the social media induced apathy they might find themselves in and realise an attack on trade unions is not just an attack on the people you read in the Daily Mail are determined to scupper your weekend, whether it might be on a train service you want to use, but we're actually part of a fundamental trend in society that's geared towards freedom, the right to free speech, the right to have a democratic say on how your life is run, the right to have a democratic say on how our economies run and how our industrial workplaces look like. That's where we see ourselves, and that's where we see this legislation aimed at. Now, what's going to happen next? Well, what's going to happen next, as far as I'm concerned, is we have got to see an organised effort to defeat this legislation. I'll be very frank, Nick, you might say different, but I've got very little faith in anyone in Parliament stopping this legislation coming through, no matter what rosette they're wearing, frankly. And that goes for this government or the next one. And I'll be blunt, I've got very little faith in any judge or legal process preventing this legislation coming through, because this whole argument of proportionality is about 3 miles off the mark as far as I'm concerned. So I don't see that as being a route to rebalancing the law in our favour or anything else in our favour. I think this is going to come down to people being organised and being prepared to fight this legislation on the streets using organised, peaceful, civil disobedience, whilst it's still legal to do a bit of it. And I think we've got to do that, because it's not just about us who are fighting for a pay rise now. And I've got to tell you, they're not a blind bit worried, this government, about nurses having above inflation pay rise. That is not what's going on. They're not worried about railway workers holding on to some conditions we might have won in 1972. They're not worried about that. What they're worried about is a shift in class power. They are worried about the ability for working class people to eat into profits in the form of wages this year and next year and the year after. That is what the real concern is of this government, and that is why they're doing what they're doing. And it ain't going to be us where they stop. If people think this is the last dig at people's rights and their freedoms, it won't be. So we have got to bring people together, and I don't think this is particularly left-wing or right-wing, or from any kind of political standpoint. I think this is an argument that should appeal to anybody who loves freedom, whether they're on the right wing of politics or the left wing. This should appeal to people who are interested and want to stand up for civil liberties. And I used to see Tory politicians who used to believe in that sort of stuff, few and far between as though they might be now. But that's really the case that we've got to make, and we've got to be prepared to take action in the defence of those principles. So that's how I see it. I won't go too far into the legislation beyond pointing out why it's cruel. I'll leave that to Nick. But I don't see how we can comply with it. There's a question about whether it works or not, and I'll leave that to other people to answer. I sincerely don't see how we can comply with it. I cannot go to a room of people like this in parts of my trade union, whether they're engineers or whether they're guards, railway workers or bus workers of any type, and I cannot stand in front of those people and tell them, your union is saying to you that you should break a strike. I can't do that, and I won't. And if I was at that meeting, I'll tell you what I'd say outside, because it wouldn't be very polite, and I'll leave it at that.
Thank you very much, Eddie.
You're welcome.
Can we get Justin up on the screen?
got what with that? Yeah.
Hello, Justin, can you see us?
Yeah, hi. Can you hear me okay?
Yes, thank you for joining us. Go ahead.
Right. Well, thanks for inviting me to speak today. So I'm the Shadow Employment Rights Minister, as you indicated in the introduction. Also formerly an employment lawyer, so I have a little experience in the area, although I'm getting a bit rusty now. But obviously, I can see with my legal background just how impractical this legislation is. Never mind all the moral and political arguments about why it's so wrong. And I think, just picking up on the previous speaker, it is about individual freedom. I think it is a huge attack on that, as well as, of course, being an attack on people's ability to collectively organise and take industrial action. And it's a act of government which I think is in a desperate situation. It knows it cannot win the fight against a whole group of workers who have, for all the reasons we know, had year after year of their pay falling behind the cost of living, and they have responded with industrial action, as they are entitled to in any free society. So I think that if this bill does go through, it won't solve any of the underlying issues that have led to this wave of industrial action, and indeed it will probably make matters worse, because there is certainly some evidence, and indeed the government's impact assessment on this bill, when it was just covering transport, did suggest actually it would probably lengthen industrial disputes rather than resolve them. So just first of all, an update on the parliamentary process before I talk a little bit about what's actually in the bill. We have had our second reading of the bill, and then next week we are having what's known as the committee stage of the bill. Now, unusually, that is going to be on the floor of the House. Normally a committee would be put away in a committee room and would go on for several weeks, if not longer. It would also include evidence sessions from experts, people who have a particular interest in the area. But that is all being dispensed with. We will have, I think, 6 hours next Monday to debate the bill, put forward amendments to try and get it a little bit less draconian. But it will be rushed through to its third reading and move to the House of Lords after next week. So that in itself is pretty unusual, particularly as we know that the government have been working on this for some time, that they now want to rush it through Parliament. But it's also a particular problem when there has been no published impact assessment, no pre-legislative consultation, and clearly with 6 hours, not sufficient time to actually debate the working implications of the bill. So hopefully that will give the House of Lords some steel to try and, if not vote against, at least try and put some helpful amendments down. But I think we have to recognise that there'll be a parliamentary majority for this, and there'll then be a battle on individual regulations when they come in. So just to sort of take you through what the bill does in outline, as you probably know, it allows the Secretary of State to set out in regulations what a minimum service level will be in a number of different sectors: health service, fire and rescue services, education, transport services, decommissioning of nuclear installations and radioactive waste, and border security. Now, as I say, it was originally meant to be purely in transport, but it's been broadened out And there are also, I think, different opinions in different government departments about whether they actually want to introduce this. I think it's fair to say transport are pretty keen, education less so. And certainly there is an argument in the health service that actually essential safety cover is already provided by the trade unions on a voluntary basis. And indeed, there is actually some legal underpinning to that as well. So it is not a bill that I think is going to be completely apparent what a minimum service will be for some time, because those details will be set out in regulations from the Secretary of State. And it is worth noting that the bill's phrased in such a way that the Secretary of State can basically decide without really having to take into account anyone else's opinion about what a safe level of service is. And that could actually mean, you could have a particularly mischievous Secretary of State setting that level so high that no one can take industrial action. And I imagine that in some of these safety critical roles, it would be quite open for them to argue that actually you do need the majority of people. And so it is a complete and utter attack on the right to strike. It's also particularly broad potentially in its impact. So transport is a good example of that. What does transport, for example, cover? Taxi drivers? We don't know. It could in theory cover those. Education, does that cover nurseries, childminders? It is very widely drawn. And just to sort of emphasize why it isn't about safety levels at all, I'm going to quote to you something that the then health minister said to me in a debate a couple of years ago in the health and care bill, when we were pushing for safe staffing levels in the NHS. And he said, and this is the quote: "First and foremost, we do not believe that there is a single ratio or formula that could calculate what represents safe staffing. It will differ across and within an organisation, and indeed across organisations. Reaching the right mix requires the use of evidence-based tools and, crucially, the exercise of professional judgment and expertise and a multi-professional approach. Consequently, we think that responsibility for staffing levels is best placed with clinical and other leaders at a local level, responding to local needs and supported by guidelines, all overseen and regulated by the CQC." So that is in just one sector. And I think it very clearly shows that whatever ministers say about their rationale for putting this forward, it isn't about safety levels. It is about stopping people exercising the right to withdraw their labour. So in terms of what will happen if these regulations are introduced, and if the bill's passed, we expect regulations will probably surface later on in the year. Once the minimum service is set by the Secretary of State, it will then be up to individual employers to determine how to actually implement that on the ground. And that, and as I'm sure Nick will talk about as well in a bit more detail, they will then issue work notices to individual employees requiring them to attend work on the day when there is industrial action. Now, this is where it gets particularly messy, because trade unions are in a completely unprecedented step, in my opinion, then required to take reasonable steps to ensure compliance from their members, and actually creates a liability for them if they fail to do so. How that on earth that could work in practice, I really don't know. And as has already been pointed out, that will put trade union reps in a position where they will become going completely against all their principles and their values, and it will I think prove to be extremely divisive. The other side of this as well is that if an employee fails to attend work, having been given a work notice, they lose any protection that they currently have from unfair dismissal for going on strike. And when the government talk about international comparisons and how other countries do this, which we think are very misleading arguments. I'm not aware of any other country where there are legislative provisions of this nature that actually also includes the power to sack individual workers. So we think it's clearly impractical. It's clearly a huge attack on working people, and we will certainly be voting against it. And we've pledged to repeal this if we get into government. Next week is the, as I say, the committee stage, and there will be a number of amendments that we will put forward to try and mitigate against the worst of this. So some of those we will be putting forward, for example, will be dealing with the retrospective aspect of this, which I think just shows you the level of duplicity that's going on here, because this bill will actually be able to apply to disputes where there's already been a ballot to take place. And I know lawyers hate retrospective laws, and I think that's a really insidious thing that is being part of this. So we're going to put an amendment to make sure that it can't do that. We're going to put separate amendments down to take out every sector that is included in the bill. We will also be requiring impact assessments from the government before they make any regulations, particularly on workforce numbers and impact on employers, trade unions, and actually equalities as well. I think there's an issue there. Another amendment will be requiring the Secretary of State to do an assessment of the level of service in that particular sector in the previous 12 months, particularly from a health and safety aspect, and actually then use that as a baseline for specifying safe standards in the future. And clearly, when we can prove quite demonstrably that actually the NHS, for example, is safer on days when there is industrial action, that could put the government in a difficult place. We're also putting in amendments requiring the Secretary of State to get a report into the impact of a minimum service in each sector from the relevant parliamentary select committee, putting in requirements to consult with trade unions, employers, government departments and select committees, rather than the current wording in the bill, which is just who the Secretary of State feels is appropriate, which again is a very broad and undefined power. We believe as well that an amendment is going to go in to basically say that consultation should take place before any act is passed, and consultations must be published within 6 weeks of the act passing into law, because again there has been no consultation, and I think we know that the response generally will be from probably not just trade unions but from most employers that actually they don't want this, they don't think this is going to help, and probably one that we will definitely try and get a vote on, and we might get some Tory support on, is to actually remove the bit in the bill which takes away the protection from unfair dismissal, which clearly is something that one or two Tories have already said they're very uncomfortable about. So this is going to be going through Parliament at a breakneck speed. I think it is well, as I'm sure you'll all agree, it's a terrible piece of legislation, politically, legally, morally, ethically. It is an absolute disgrace, and we will do what we can to fight against it. Thanks very much.
Thank you, Justin. Final speaker is Nick, and hopefully we'll wrap up the speaking in about 15 minutes. So we have time for questions.
Yeah, I've done some slides. I'm not going to. I sort of went into overdrive when I was doing them, and so there's about 38. But I'm going to use it for a briefing paper and an article. Actually, I just want to highlight a few points. I think in less than 15 minutes, so there's time for questions. I think that's what I'm going to do. The first point to make, then, is I want to focus on is why is this happening? We, of course, are experiencing a tidal wave of industrial action. Certainly, probably in terms of days lost for industrial action, it's probably the biggest number of days since probably the 1980s, with possibly the exception of 2011. And I've set out in these notes just some of the days lost for industrial action to illustrate that. The response of the government so far to any of the strikes has not been to negotiate or attempt to talk to anyone, actually, but instead, they're basically, as far as I can see, trying to ride it out at the moment, and at the same time, they are preparing a new and very significant assault, as has been talked about by the previous two speakers, through the introduction of this bill on trade union rights. And really what we're seeing, coupled with the public order bill, is really, I think, a government now which is looking really to suppress any form of dissent or protest against what they're doing in this country at all. And that is really what is going on. And I just want to talk a little bit, I've got, there's lots of things in this presentation, but I just want to talk a little bit about why we're here. So the next slide I was going to look at is number 9, actually, for anyone who's flicking these things over. Up until the late 1960s, there were no anti-trade union laws or even attempts to control the trade union, certainly since between World War II and that time. But basically, the two sides of industry were left to get on with it themselves. What started to change was that the world economy moved into growing crisis towards the 60s and in the early 70s. And that period of laissez-faire within the industrial field had led as well to the trade unions really growing in strength enormously, and also quite significant social and economic gains as a consequence for ordinary people in this country. And so it's a period since the war. We saw the health service created, state education, public ownership of significant sectors of the economy, legal aid, the taxation system. I'm just going to mention this very briefly, being used to significantly redistribute wealth. I mean, I don't know how many of you are aware, but in 1979, when that Labour government left power, the top rate of income tax was 83%, and the base rate was 33%. Which is very different to the picture we have today. Now, the growing economic challenges that the country was facing, I think, led to the establishment in this country and big business coming to the conclusion that enough was enough and this needs to come to an end. And in fact, in 1968, you saw the first attempt at possibly restraining the trade unions with a bill introduced by the then Labour government called In Place of Strife, that didn't get anywhere. But it did, of course, then lead on to the first serious attempt to introduce anti-union laws with Edward Heath and the Industrial Relations Act in 1971. Ultimately, he was defeated, and he was defeated in many ways because I think he just tried to do it all at once in one big fail swoop. And it led to a reappraisal of strategy. And from the election of Margaret Thatcher in 1979, a far more carefully calculated and brutal offensive was launched at that time in many different directions. It was an ideological offensive, and you can still see it pervading all our politics today, of neoliberalism, of business is best. If you want anything to be done, you need a businessman. Every time we listen to people, we need more businessmen. Businessmen are great, we've got to work with business. All of that is a reflection of the ideological offensive that started with Margaret Thatcher and indeed Ronald Reagan in America in 1979. Deregulation in all sorts of areas. In fact, we're about to see the biggest single deregulation with the freedom from the EU bill, which will basically remove all of the regulations passed under EU law at the end of this year, but all sorts of areas. And of course, the people at Grenfell, as we know, amongst others, paid with their lives as a consequence of some of that. And amidst all of this, the trade unions were targeted as being one of the bulwarks, sort of underpinning all these social gains. And they were targeted, not actually initially with anti-union laws, or they were brought in. They were targeted with a very carefully worked out strategy in a report produced by someone called Nicholas Ridley, who subsequently became a minister in Margaret Thatcher's government, which was a careful plan, basically, to take on and break the trade unions, starting with some of the smaller unions, such as the steel workers, who went on strike in 1980, the train drivers who went on strike in 1982, the printers who were involved in various strikes in 1983, and of course culminating when many of those strikes, all of those strikes ultimately were really defeated, with the miners' strike in 1984 to 85, which was a major industrial defeat, followed then by the printers at Wapping and also the dockers around that time as well, one after the other, and a carefully calculated plan, involving the use of the police, involving the piling up of coal at pit heads, a very carefully orchestrated plan. And the anti-union laws, interestingly, didn't really feature in it. They weren't used in any of those industrial disputes to any significant extent. But what they did, as they were brought in from 1980 onwards, was really to cement down the trade unions, having been broken, so they hopefully, from the point of view of the establishment, wouldn't rise again. And so we saw then that the anti-union laws, starting off with 1980, I'm not going to go through all of them, but starting off very innocuous employment acts brought in by Jim Pryor, getting more and more draconian as each new legislative measure was brought in. And it did undoubtedly have the impact, eventually, both the industrial defeats that took place, plus the anti-union laws, of really bringing the trade unions, as far as the establishment were concerned, to heel. And you saw from 1980 onwards, industrial action and days lost of industrial action plummeting, really down to very low levels, and the union membership going down as well. The high point of union membership was 1980, when there were 12 million trade union members, and by the sort of 1990s, that had more than halved, in fact, and many unions were seriously, in fact, unions like the NUM had effectively ceased, to all intensive purposes, to exist as a consequence of the closure of the mines. Dockers Union, again, the docks were largely deregulated, and the dockers, moved, and so on. And of course, despite all of that, I mean, one of the, if you study labour history, one of the interesting features is that every attempt ultimately to try and rein in and stop trade unions by legal action doesn't work, because they ultimately represent a very significant part of our society, and they can't just be made to go away. And I think that's what we're seeing has happened, is that despite all of these laws, one after the other, and added to by the Trade Union Act in 2016, which introduced the requirement to have 50% turnout, introduced a requirement for certain services. In fact, it's an identical list of services now in the Minimum Services Bill, was in the Trade Union Act of 2016, requiring those particular services to get a 40% threshold in order for a strike to be valid of those actually entitled to vote. Those that further legislation was introduced, but despite all of that, they haven't stopped ultimately the determination, when people finally have had enough of standing up for themselves and taking part in industrial action. And so all of those laws, everyone, the RMT, all the other unions more recently have achieved far in excess of the thresholds in the ballots. And I think what it reflects is that the neoliberal agenda, far from it creating, as was portrayed at the time, a more prosperous society, the trickle-down economics was, that if we allow the rich to flourish, then the benefits will come to all of us. And sort of 40 years later, not a drop has arrived in reality, and people, I think, have just had enough. And I think that's what's happened. And that's what I think these strikes aren't really about pay, I don't think. People have just had enough of year after year austerity, attacks on working conditions, working in schools, unbelievable hours, working in hospitals with more and more staff not being there anymore because people are leaving in droves. People have just had enough, and that's what has led to this industrial action. And the response of the government is really more of the same. And it's now culminating in this new bill, which is a draconian measure. But we want to the next point. It's a very ill thought through measure, one would have to say as well. When you examine, it's really, I think, been quite hastily been put together without really thinking through the consequences. Just to give you one example, the previous enactment of this bill was the bill which was introduced last year, which was just aimed at the transport industry. And that was just to have minimum service levels and the provision for minimum service levels in the transport industry. Now that was accompanied by a paper drafted by the government on its impact on human rights, and whether it's compatible with the European Convention of Human Rights and the provisions in international employment law, such as the International Labour Organization. And interesting, what that paper says is that these measures that they were going to introduce for transport were justified because, unlike other areas such as health and education and indeed the fire service, where there already were measures in place, they didn't need those sort of laws, but they were needed in the transport industry because there were no provisions there to enable minimum service levels or to be imposed or agreed. You think about, so basically they've actually produced a paper only last year saying that these measures are not needed in all these other areas because they already have provisions in order to cater for those other areas. So, and indeed in most of those other areas, there will be, like in the fire service, in the health service, there will be negotiations to ensure that people aren't put in jeopardy. Such measures include, for example, Section 240 of the Trade Union and Labour Relations Act, which basically stops you taking any action which will affect life and limb. And agreements are put in place to ensure that sort of thing doesn't happen. It's all already there. And they've already accepted it's already there. And yet now, of course, the new paper says we need it all these services, it's needed. And the other interesting thing that I think it's not really thought through is that Grant Shapps, when he introduced this legislation on the 10th of January, made big play about this is all about safety and ensuring that no one is jeopardised by any of these strikes. And when you read through the papers and briefing papers they've produced so far, and there's nothing about safety at all. It doesn't get mentioned. Of course, in the transport industry, there's no safety issue of any sort, in fact, because simply the fact is there's no trains. Nobody's in any danger, because there are no trains. And indeed, the International Labour Organization and other international human rights bodies have, in fact, already concluded that, in fact, transport is not a basic essential service. It's a service of high importance. And the ILO has suggested that that may be a service where a minimum service level agreement might be appropriate, but not in the way this government is doing it. The ILO would say, well, what's needed instead is there to be negotiation, there to be agreement between the union and the employer, and there also needs to be, if you are going to take away or weaken the right to strike of any group of workers, some form of alternative, arbitration, etc., to address their just concerns if they can't take more effective strike action. Now, there's nothing like that in our legislation. It is simply the Secretary of State will be empowered to impose minimum service levels on the 6 areas which have already been mentioned. Another interesting difference as well between what's now being proposed in the transport legislation is when the Transport Minimum Service Bill was introduced, it didn't just say the Secretary of State could impose all of the minimum service levels, but in fact, it did say that there should first and foremost be negotiation and an agreement between the employer and the unions. Secondly, if agreement was not reached, it would be referred to the Central Arbitration Committee, which is a quasi-judicial body, which would then determine the dispute and what the level of minimum service is required. And only as an absolute fallback position would the Secretary of State be able to make regulations. Now, all of that is not in the new bill. Instead, it's purely the Secretary of State, Grant Shapps, can impose. He does have to consult, but only such persons as he thinks fit. There is no definition of what that means, and it's a duty to consult, but only such person. So that doesn't mean anybody, really, ultimately, because he may decide that there's no one fit to consult. Who knows what he'll decide? Certainly, there's nothing in this bill which identifies who you have to consult. Nor is there any guidance as to what is a relevant service. We've got the 6 categories. In terms of what services will fit in from those categories, there's no guidance at all. It's entirely left to Grant Shapps to decide without any sort of remit, without any sort of guidance. That was different again to the previous proposed legislation. And he will decide the minimum service levels. Now, how he's going to do that in relation to education, for example, is a mystery, really. You know, every school in this country to impose what is a minimum service level. I mean, that was one of the reasons they gave in the previous paper on human rights for the minimum service transport bill as to why it wasn't appropriate to introduce it in education. They said it wasn't practicable to actually work out what that minimum service level would be. But nevertheless, that's now what is in this legislation. So it looks like, and I'm not going to go into any more detail than that, but it looks like it's extremely poorly thought through. Now, final point I want to make is I actually agree with Eddie that I don't think that any trade union would be sensible to rely on legal action or lawyers or anything in order to defeat this legislation. And I don't just say that about this legislation. I think ultimately the law is at best an auxiliary for trade union and industrial relations matters. The courts are not the most favourable forum by any stretch of the imagination for trade unions and trade union members. And indeed, again, if you look at the case law in relation to industrial action, the arguments that will be entertained by judges as to when a ballot provision in the Trade Union Labour Relations Act has been infringed, you know, a lot of it is almost mind-boggling in that you just couldn't think, no one could seriously entertain that, but they do. And that's because the courts are not sympathetic to trade unions. So I think it would be very unwise to rely, or indeed encourage members, I think, to think that it's all going to be dealt with by legal action, and they can sit back and wait for that to happen, only to be demoralised when the judgments come through. But that doesn't mean to say it's not worth, at the same time, I would argue, at least trying to tie up the Secretary of State and employers in a legal nightmare, because I think that's what they'll be heading into. And the final point I make, I don't think this stuff is compatible with the European Convention of Human Rights at all. You know, it's just so vague, it's so ill-defined, and you can't say that even, you know, essential services. I mean, education obviously is in one sense an essential service, but no one's life or safety is jeopardised if you go on strike as a teacher in reality, or save in perhaps very limited circumstances when there will be safeguarding type issues in the school. And so I think there'll be, each regulation that comes forward will be, there'll be opportunities to challenge. I've set out some ideas in my paper, but I think this is something though which won't be beaten ultimately. I think law may help possibly, but it's something that ultimately is going to need far more than legal action if it's going to be stopped. And stopped it must be, because if it's not, then it does further really challenge almost the right to exist for trade unions in this country, and it will be a further step to consolidating what the last 40 years has achieved, which is the rule of the rich in our society, the complete and utter domination of every aspect of our lives, their complete control of wealth in our society, which ultimately is what the neoliberal agenda has been about. So that's my points. And anyone have any questions?
Thank you, Nick. So we've got about 10 minutes for questions. We started a bit late, so we can maybe run over slightly. Has anyone questions for any of our speakers? At the back, I think we've got a mic roving somewhere.
You shout without it. I'll take the mic if it's going. I'm not sure this is doing anything, is it?
No.
We can hear you though, we can hear you.
No, it's fine, I think you'll be... Yeah. No problem.
Thank you very much. My name is David Romer. I'm a solicitor at the National Education Union, and I've got a question for Pippa and just a kind of general comment relating to something that Eddie said and that Nick said as well. First, for Pippa, in relation to the Public Order Bill, these new measures that are going to be available to the courts and to the government, the serious disruption prevention orders and the Home Secretary's civil injunctions, are those repressive measures only available as against individuals, or can they be used by the authorities against organizations like, for example, a trade union or Extinction Rebellion or a feminist organization that was involved in the Sarah Everard protests? And just following on from that, could they be used to deplete an organization's financial resources or potentially even bankrupt a smaller organization? Then the comment I wanted to make was that I completely agree with what speakers have said, that both proposed bills are anti-democratic, they're anti-working class, and I absolutely echo what the speakers have said about these bills, or this proposed legislation, the fact that it can't be stopped, it won't be stopped through Parliament, it won't be stopped, I don't think, by judges, and certainly if you're relying on a handful of rebel Tory MPs, that's cloud cuckoo land. That's not going to happen. What's important is what's going on in the streets, what's going on particularly in the workers' movement. So in practical terms, really all I want to say is, if you're against this bill, probably the best thing you can do to oppose it is A, support the strikes that are going on, and B, look to the rally on the 1st of February, when a number of unions are all going to be taking action on the same day.
Here. In response to your question, David, the legislation is drafted in such a way that it is targeted at people. So it's phrased in terms of, if P, a person, causes X, Y, Z, then the order may be imposed on P. That's not to say that it can't be used to target organisations in reality, because these, as I say, were modelled on football banning orders. And we see huge groups of people getting trucked into the courts to face civil proceedings in respect of those sorts of orders. And there's no reason, for example, why a significant group of people couldn't be all subject to simultaneous applications in respect of activities taken on a march, in a protest, etc. And the conditions that can be imposed, as I say, stop you from fraternising with named others, from going to certain places. So they can be used, notwithstanding that they have to be targeted at the individual. I think they can be used to weaken community and group action in that way.
Yeah, second row.
Hi, my name's Charlie Heintoff. I'm a PGDL student at Nottingham Trent, and I've just started volunteering with the Green and Black Cross as a Know Your Rights trainer. So I'm feeling quite pessimistic about this, unfortunately. I mean, I'll be on the streets using my right to protest until it's taken away from me. But what can we do, to prepare for the worst case scenario for this? And also, I just thought it was really interesting in the public order bill that, on the one hand, it includes a defence for trade union disputes in the very same industries that they're also taking away those same rights from, which I just think is bonkers. But thank you.
Yes, yes, there is. I think that's an interesting point, that they do in respect of the obstruction offences for the key infrastructure and the rail. They have there is a defence of if it is to do with a trade union dispute, but it can only be directly to do with. So again, there's this vagueness, and as Nick said, we can't necessarily rely on the courts to interpret that in a way that's favourable, and certainly not the police to interpret it in a way that's favourable. So I think, caution as to how protective that defence really is. In terms of what we can do to prepare for the worst, I think the only way to protect protest is really, as others have said, to protest. I mean, the predecessor of this bill, the Police Crime Sentencing in Courts Bill, was set back. I mean, obviously, eventually passed with some amendments, and these provisions are in fact the ones that were voted down in the Lords. They were added late, voted down, and now being reintroduced. But there was, I think, a turning point in the passage of that legislation when we had actually the Sarah Everard vigil and those scenes, and suddenly the public understood that protesters didn't just mean Just Stop Oil or Extinction Rebellion, or indeed Black Lives Matter, if you don't like that group either. They also mean, frankly, nice middle-class white women in, mourning somebody, that also counts as a protest. And actually that could be me. There's so much othering. I think we need to make the case that this is a right that really concerns all of us, not just people over there who've got other things to moan about that don't affect me. So, I mean, it's not a particularly satisfactory answer, but I don't see what other answer I could give.
Any other questions? Front row, back, Laura.
Hello, my name's Laura Thompson at Slater and Gordon Solicitors. I'm here with 3 colleagues who work in the employment team. I would like to know what you think of the reception these bills are going to get in the House of Lords, and whether there's a realistic possibility that they'll be delayed beyond the life of this Parliament, and whether or not you think actually they're probably going to become law, but then it will be dependent on a Labour win at the next general election for those pieces of legislation to be repealed or revoked.
I think we might have lost Justin. He had to go off somewhere. Does anyone else have a view?
Yeah, here you go, press your button.
Thank you.
I've got no hope that it's going to be prevented going into legislation. It might be delayed slightly in the Lords, but the government is in control of the timetable. Rather than having a usual committee stage, as I understand it, they're going to have a grand committee on the 30th, which will be just giving the legislation to the House of Commons and inviting amendments and all the debate that might have happened in committee stage in the room. Then it will go straight to the Lords. There'll be some to and fro in here, but I don't expect it will be delayed for very long. And I have to tell you, I don't expect a future Labour government to repeal the anti-trade union legislation either. I've been around long enough. We were waiting for a previous Labour government to repeal the anti-trade union legislation that they pledged to repeal back then. And I don't say that as any, political point scoring. It's just plainly what I think. And I think people should be pessimistic. The trade union movement has taken a kicking for my whole life. And that's undermined, really, the strength of protest in this country. Protest has been undermined for many years. One of the, pillars of the protest movement in this country was the anti-war movement, which has been completely crushed. And no one is prepared to associate or ally themselves to in this political moment, at least when things are complicated and difficult abroad and in relation to foreign policy. Freedom of speech has been undermined drastically over the past period, and a lot of that has been sadly promoted and given a progressive sheen by a lot of people who frankly should have known better. And now we find ourselves in a pretty dire moment. So you should be pessimistic, because it ain't going to be easy. But they don't call it the class struggle because it's easy. They call it that because it's difficult. And I've got to tell you now, there's people out there fighting tooth and nail to protect the scraps of what they've got left. But at the bottom of it, you've also got to be optimistic too. And I think that, I do think that people can be moved by example. People can be moved by example, but it's got to be meaningful. And it's got to reach people where they are. And it's got to reach a lot of people in a similar fashion. And that doesn't come about without organised effort, sacrifice and hard work. So the future's looking a bit rough, but we've got to get our tin hats on. There's a war on. And that means we've all got to do our bit and we've got to fight hard. Because if we don't, we'll just be another generation that accepted a pat on the head and went quietly down the road whilst things went worse and got worse for our children, our children's children. I'm not prepared to do that. There are plenty of people out there that might be, but I think we've got to lead by example and give people something to fight for.
Anyone else?
Oh yeah, I've
Front
got a
row.
mic. Just a quick wee question. My name's Saskia O'Hara. I'm from Public Interest Law Centre. I'm also a local housing campaigner, and best believe we're going to come up against this because we protest every weekend. Anyway, just wondering from any of the speakers, or actually anyone in the room, if anyone knows of any group of legal professionals or body that's starting to prepare for this coming in now. Can we launch legal challenges immediately? We can do preparation because we know what's coming. So maybe somebody knows about it, maybe it's something we can do, but just wanted to throw that out there.
That's a no. But I'm definitely something. Let's talk. I mean, I think Police Action Lawyers Group and that group of people is full of people who I'm sure are having the same thoughts, even if they're not talking about it collectively. So yeah, let's chat.
Yeah, just on the previous question, I mean, I'm not desperately hopeful of the House of Lords coming riding to the rescue. I think, Lord Hendy and certain others will make every effort to stop and delay the legislation, but I suspect they won't be able to. One interesting point about that actually is that the Tories do not have a clear manifesto commitment for much of the legislation or the new bill. They do the minimum strike transport sector was in the Tory manifesto in 2019, but the rest of it, all the other services they've now roped in was not. So it's not a manifesto commitment for a large part of this bill. That means the House of Lords could potentially delay and stop it. They can't use the Parliament Act. However, I'm not desperately optimistic that will happen. And it will come down to, I think, what happens afterwards. And that'll be two things. One, hopefully there will be more and more resistance, because I do think that it's being introduced at a time when people really are at the end of their tether, and that's why we're seeing these overwhelming majorities in strike ballots. I mean, the barristers' dispute has settled, but even barristers, if you'd have said to me 20, 30 years ago that barristers would be able to achieve an 80% vote in a ballot for effectively an all-out strike, I'd have thought you were mad. But nevertheless, that's what happened last year. And I think that's just it's where people are at the moment, that they've just had enough. So maybe, but there will be significant resistance to it. And I do think the legal side of it, we shouldn't underestimate, and we should prepare for legal. I'm sure we are. That's one of the purposes of this evening, in some ways, is to start discussing how we compare. Now, obviously, there's not much you can do at the moment because it's just a bill. But I think that because it appears to have been ill thought through, and because a lot of it is so vague, and a lot of it doesn't appear to easily comply with things like the European Court Convention on Human Rights, then I think particularly the regulations may well be susceptible to legal challenge. And that will need to be looked into very carefully, and possibly work notices as well, because the statutory power in relation to work notices is for people who are required to carry out the minimum service level. Now, there's no guidance whatsoever as to how they work that out. And that may be something which can be looked at as well in terms of legal challenges, as well as an attempt perhaps to challenge the whole thing. Or that's more difficult because obviously Parliament is supreme in this country, and even if you can get a declaration of incompatibility, which may be possible in relation to this legislation, although I say I'm not a great believer that the courts will ride to the rescue of the trade unions. They're more likely to ride to the rescue of the Tory government in reality. That doesn't achieve anything ultimately, because so what? The government will just say, well, we're not being dictated to by Europe, and they'll just carry on. With the legislation, confusing deliberately European Convention of Human Rights with the European Union, which of course we've left. So I think I'm hoping, given the period we're living through, that people have had enough, and they won't find it an easy ride to get it through in terms of protests and campaigns on the streets. But I think there may be possibilities for legal action, at least to try and tie them in knots when they try and introduce some of these regulations, and I think that certainly will be worth exploring, and certainly I certainly will be trying to do that.
We've got time for a few more questions. For any more, third row.
Barinder Kataria from the Pharmacists Defence Association. Just to reinforce the point about everybody being fed up, our members in the NHS, pharmacists, you don't really see them as being militant, but our members in the pharmacist members in the NHS are actually asking us to ballot them for strike action. And the question I really just want to ask is, probably it'll be for Nick. I know the government were trying to push through limitations on judicial review. Will that have any impact on our ability to sort of challenge some of this legislation?
Nick or Pippa?
I think I've taken. I'm happy to take
That
it.
is something, I'll be frank, I haven't thought about. I can't think that it would necessarily, but it's something that obviously have to be looked into as to whether that will be possible. And
I don't think it should pose a significant challenge as long as you've got somebody who has sufficient standing, and you've got, and you haven't got the difficulties. Increasingly, it's difficult for people like public interest lawyers or NGOs to bring these types of strategic challenges. So it's about trying to find the right case, but with the right case, it should be perfectly possible with the right arguments.
I think the other point there is often these things go hand in hand with what's going on outside the courts, because sometimes, where the courts do sometimes step in is where things are getting out of hand because the government's overplayed its hand, and the courts will and legal officials will step in. I mean, I'm unfortunately nearly sufficiently old enough to remember the 1970s, and the Pentonville Five, for example, when they were imprisoned. There was huge demonstration marching down towards Pentonville Prison, which was getting bigger and bigger. But for those of you who don't know anything about this, in 1972, 5 dockers were imprisoned for defying the Industrial Relations Court, and they were sent to Pentonville Prison. And there was a huge demonstration and an uprising almost. The TUC was on the verge, I think, of declaring some form of general strike. And the official solicitor bobbed up out of nowhere and let them out. And since that time, they have never focused in terms of the anti-union laws on individuals.
No.
It's always been on the unions and the union funds is where they focus on. This is slightly different because, of course, individuals can be sacked, but they've never focused in terms of imprisoning union leaders and etc. Because of, I think the example that martyrs is basically what you create, and so they don't do that. But that's an indication that when the courts will come riding in, is where things get out of hand. So I think if there's a lot of action going on outside, that's when you might see the courts restraining some of the excesses of the government to try and make sure that things don't get out of hand and lead to more being questioned than simply the legislation.